Okay, as you already know, today should be day 32 of our 12 weeks legislative drafting course, and this is week 7. We are dealing with miscellaneous provisions. Yesterday, we kind of introduced this topic, letting us know what miscellaneous provision is, the origin, the history, or the roots, or the etymology of that particular word, miscellaneous, tracing it to the word miscellus, and also, which means a mix of things. And we used an analogy like the bag of a woman, in which you can see an assortment of different things. On the extreme, I used Lagbaja's video, but you can actually see a lot of things different. You can see thread and needle inside the bag of a woman who has dressed for office, not because she intends to use the needle to fight somebody or what, no, but she's just trying to be proactive in the event she's walking on the road and by chance or accident her clothes gets torn, one of her buttons falls off. She shouldn't just be in that precarious position. She should have a remedy. She should have a solution to that problem. And that is what miscellaneous provision, that's the purpose it serves. You arm yourself for unforeseen circumstances, eventualities that may throw themselves up. They are not really unforeseen per se. It's just that you, as a draft person, you should look beyond the immediate and try to do a forecast, do a projection into the future in line with implementation of the law. What could be a hindrance to this law? What can just be a hindrance? Okay, to what could even bring confusion? What could bring ambiguity? And that ambiguity leads to non-implementation of this law. So it is under the miscellaneous provisions that we solve those problems. One, miscellaneous provision confers jurisdiction. It is under miscellaneous provision that you say it is the state high court, or it is the federal high court, or it is both courts that should have jurisdiction. Miscellaneous provision also provides limitation of action, notices, reaction notices. It also talks about continuing offense. What should we do? So a lot of things are mixed up there. Now, we also talk about issue of enforcement. What is the procedure? Issue of warrants, issue of search, offense by a corporate body or a corporation. How do we go about it? What is the procedure of reporting? Who is in charge of investigating or instituting an action in the event of a particular offense had been committed? We cited the example of EFCC Act and the case of EFCC against Ibori and Ibori against EFCC. We have a lot of those cases. And when the EFCC Act was initially enacted, the early 2000s, the drafters erroneously omitted to specify which courts that had jurisdiction. That became a lacuna. And the defense counsel harnessed that lacuna very well to the advantage of his clients. So if you arraigned Chief Ibori before the state high courts, he will raise the objection that the EFCC Act does not confer jurisdiction on these courts, and the matter will be struck out. You bring it up another charge, okay, you take him to federal high court. He will raise the same objection. My lord, this court does not have jurisdiction. And that led to multiple amendments of the EFCC Act, which ordinarily ought not to be so. And I did say that as at the last count, that particular act had been amended up to 52 times, 52 amendments between year 2000, 2001 till 2023. 52 amendments. And we are not sure whether that is the end. A novel issue can come up tomorrow that will also require further amendments. But it's also good because it is enriching our jurisprudence, just that it is exposing the negligence of the draftsperson or inelegance of the draftsperson. We also looked at the example of the Terrorism Act, where the first act did not confer authority to prosecute, prosecutorial authority, on either the DSS or the police, leading to a situation where both agencies were dragging.
That's the equivalent of DSS.
Okay.
Some of this you have to
explain. Okay, thank you, sir. Now, the DSS is the state security agency at the national level. So, they gather intelligence for the states, and the case in question was of a bomb blast. The prime suspect was arrested, and when he was arraigned in court, the DSS came to say, this is within our jurisdiction, we are the ones with the power to prosecute. Then the police says, no, this is within our jurisdiction, we are the ones with the powers to prosecute. And that confusion created a loophole that the counsel to the accused harnessed to say, my lord, these people are dragging power to prosecute. The Anti-Terrorism Act, the Terrorism Prevention Act, did not confer power to prosecute a terrorism suspect to either the police or the DSS. So, my lord, both agencies have no power to prosecute the defendants, and the court had to strike the case out. And I did say that when these things happen, the public or the population or the masses, they do not understand the intricacies. And the media too, the media is not helping matters. The media will just give one sensational headline. Courts, they may not say acquits. Court frees terrorism suspects. Court strikes out charges against terrorism suspects. Full stop. A lot of people will not have the patience to read or discipline to read that news item to understand what actually transpired. They will run with the headline and start abusing the judges. Yes, the judiciary is corrupt. They have collected money. They have compromised the case. They have no interest about the lives of people that were destroyed and all that. They will accuse the prosecutorial agencies. How can you say DSS does not have power? How can you say police does not have power? Nigeria is not a country. If it were in America, if it were in UK, if it were in India, if it were. Now, this whole problem was caused by that negligence in conferring jurisdiction. Now, the cost is, one, the precious time of the court is wasted. Another cost is that state resources is wasted. Another cost is that the precious time of the legislature is wasted because that particular act has to go for amendment and it will go through the whole process again. So the time that the legislature would have invested in doing another duty, they are coming to repeat what they have done before. So the 52 amendments of the EFCC Act means that the legislature converged 52 times or convened 52 different times to keep amending one act. So I want us to understand the far-reaching effects of our negligences in drafting. So you might think it has no effect. It is just, okay, I just didn't put jurisdiction. Now we can put it next time. It is far beyond that. And I also say that how you test the effectiveness of your bill or your law, because that bill will eventually become law, is that when it is tested in court, it stands the test of time. So assuming all those times where preliminary objections are raised, the court resolves it in favor of the state or in favor of the prosecution. That means that your bill or your law is airtight. The draft person did a marvelous or excellent job, so there are no lapses there. But where once you raise any objection, the courts oppose that objection, it tells that there is a lot of error in that particular piece of legislation. So another thing that miscellaneous provision takes care of is for election petition now, the duration of trial. You can see 180 days. So whatever thing you're doing has to be done within that 180 days. You cannot wake up and give any excuse whatsoever. Some cases, in some cases, Edo State, there was a security challenge with the panel there. Some people were coming around the venue to disturb the panel. The panel relocated to Abuja. Why? They are time bound. Benue, currently, in fact, this morning I was reading that the panel has been asked to reconvene at the High Court. Why? Because one of the preliminary provisions is that this electoral tribunal must not exceed 180 days. So that is what preliminary provision does. It aids you in implementation, or rather in actualization of your principal provisions, which is the main body, which is the main thrust of the law. Any questions so far, please? Any questions? Any questions? Questions. I'm not seeing any hand up. Should I assume? Oh, Dr. Edima, good afternoon, ma. Good afternoon. Hannah, good afternoon. I can see you now. Okay, Mr. Emmanuel, your hand is raised.
Good
I was
afternoon,
looking for your number.
Benisa.
Thank you, ma.
Good afternoon, Benisa. Well done.
Thank you, ma. Mr. Emmanuel, your hand is raised. I was looking for your number 2 days ago to tag you on a post I made on the platform. Hello, Mr. Emmanuel. Yes. You have the floor, Mr. Emmanuel.
Hello, sir.
Yes, thank you. I said I
Yes,
made
sir.
a post on the platform.
Yes,
I don't know if you saw the post I made about public hearing. I shared a post on the platform, public hearing on the tax bill. And I was looking for you specifically to tag you because I remember in one of the sessions of the class, you mentioned that public hearings are not usually advertised or people do not know about it. So when I saw this one, I think Senate is 24th yesterday and today 25th. Then House of Reps is 26th and 28th. So when I saw it, I posted it so that you might be interested in attending. That's why I shared it. Go ahead with your question, sir.
Thank you very much, sir. I'm sorry I was not able to attend the class because of the nature of my job, sir. So please, in
Okay.
respect of this question, I mean this today's lecture, I
Yes,
tend
sir.
to ask because you our facilitator is explaining to some things to us in respect of the prosecution and charging of the case to courts, which is solely responsibility of Nigeria police. My question now is that, please, though I am a police officer, but I want to ask, sir, is it officially indicated in any act or in police act, or is just being assumed that it is Nigeria police, it's only Nigeria police that can charge the case to court and that can prosecute
It is
case
not
to
only
court?
Nigerian police that can charge the case to courts. It depends on the nature of the offense. For example, NAPTIP is there. If they like, or let me not even use NAPTIP. And I say Nigerian drug, yes, now Nigerian Drug Law Enforcement Agency. Now, if there are cases of possession of cannabis and all that, or even cocaine, all those people they arrest at the airports. Once the police does their investigation and the NDLEA goes and confirms what the substance is, they charge. Do you get? Now, the Establishment Act confers jurisdiction on who should charge, depending on the nature of the offense. Do you get it?
Yes, quite
NAPTIP
all right. I get it. I get
has
it.
its own lawyers. If there are cases of human trafficking, because that is where NAPTIP comes in, do you understand? National Agency for the Prohibition of Trafficking in Persons. Now, if there are cases of human trafficking, child trafficking, baby factory and all that, it is under their purview. Once the case is reported, they also have police people working with them. They have their own lawyers. Do you get? So they charge, provided that the Establishment Act empowers them to so do. Is that explanation clear, sir?
Yes, please, please, but so, sir, thank you very much. So, in the next time, because I used to hear most of my colleagues used to say it categorically that no nature of kind of offense that can make another organization to prosecute, charge with case to court, to prosecute and in the court, that is solely responsibility of police. I used to hear my colleagues saying that, but I did not have evidence of arguing in support or against the motive.
Okay, but you
So
have
that
a
is why
clearer
I
understanding
could not
now.
say anything about it.
But you have a clearer understanding now with my explanation, right?
Yes, quite understood now,
Now,
sir.
understand one thing. The police is saddled with the responsibility of maintaining law and order within the society, right?
Okay.
One. They also are saddled with the responsibility of arresting, maybe still within that line, civil unrest and all that. Then cases of crime too, the police charges. Now, example again, EFCC, Economic and Financial Crimes Commission. Former governor of Kogi State, Yaya Bello, was charged to court, and a whole lot of others. Emefiele, the former central bank governor, was charged to court. Was it by the Nigerian police? No, by the EFCC, because that is their domain. And the Establishment Act empowers them to investigate cases of economic crimes and charge accordingly and prosecute. So in that case, EFCC lawyers will go to court on behalf of EFCC. It is not police that is charging in this case. The ICPC is there too. Independent Corrupt Practices and Related Offences Commission. So they look at corruption within the civil service, corruption related matter, different from economic crimes. So when ICPC investigates the matter and concludes it, and they see the need to charge the person, the ICPC lawyers will frame their charges, and the suspect or defendant will be charged accordingly by ICPC, not the Nigerian police. Why? Because the Establishment Act of ICPC empowers them to investigate corrupt practices and prosecute accordingly. So it is not correct, sir, that it is only the police that has the power to prosecute in every case in Nigeria. So different agencies have their jurisdiction. So I have cited the case of Oga Obi, you will just respond. I will call you up quickly soon. I have cited the case of NDLEA. I have cited the case of EFCC. I have cited as an example, of NDLEA, the example of EFCC, the example of NAPTIP, the example of ICPC. Then cases that border on treason, the DSS comes in. Why? You are threatening the internal security of the nation. You are threatening the authority and power of the sitting president. Mr. Obisa, you have the floor.
Thank you very much, sir. If we have a situation where a criminal enactment fails to provide a specific prosecutor, can the police be the default prosecutor?
The police can be the default prosecutor, but it is going to bring a challenge. That is what happened in the Kabiru Sokoto's case, the Nyanya bomb blast suspects.
Okay.
Do you understand?
Yes.
The Anti-Terrorism Act or Terrorism Prevention Act is a penal legislation.
Yes.
Preventing terrorism.
Correct.
You understand? And it failed to specify a prosecutor or a prosecuting agency.
Okay.
The police assumed that position. The DSS assumed that position. Started bringing conflicts. And the lawyer smartly harnessed that conflict to say, my lord, this act did not specify a prosecuting agency. So both powers, because by our laws, you cannot exercise a right, a power that is not conferred on you expressly. You cannot assume that you have this right. You must show us in the law where it is written black and white that it is your duty or power to perform this function.
And we don't have common law of crime here.
Sir?
We don't have common law of crime, so everything must be written in black and white.
Beautiful. So we do not assume. That is why in your miscellaneous provisions, you have to be as detailed as possible. Anything you remember that might be a clog in the wheel of achieving your principal provisions, you include it in your miscellaneous provision.
Wow. Thank you very
And
much.
that's also because you are human, you are limited in knowledge, you do not know what may come up tomorrow. That is why you now have power to make supplementary regulation conferred on within that particular act, so that tomorrow, if there are circumstances beyond control that shows up, like what we experienced during COVID, it was unforeseen. But you do not, even the National Assembly was observing sit at home then. So you do not wait for the National Assembly to convene to make a regulation. The head of the agency or commission has already been empowered within that act to make subsidiary regulation or legislations towards the achievement of the provisions of the act.
That's
Yes,
correct.
Mr. Oscar, your hand is up. Mr. Emmanuel, I will call you after Mr. Oscar. Prosecute. It wouldn't have cured it because that would be ambiguous. So part of what you will, anything that we give two or multiple interpretation to a particular provision of the law, you remove it. So the law has to be specific and certain. Certainty of the law is part of your goal as a legislative drafter, that you cannot interpret to say, if it is not this, it is possible they meant this. No. At that point, there is ambiguity. Once you hear it is possible that it is this they were referring to, it is ambiguity. So you have to be certain. Yes, Mr. Emmanuel, sir.
Thank you very much, sir. First of all, I'm very sorry to switch from this present topic of prosecution to something that's relating to this legislative drafting as well. My questions
Okay.
enter on a particular post that public writing that our prof Jaja and Tonye, the publication that he made recently in respect of the former president of Americans invitation, trying to convince former president of Nigeria, President Goodluck Ebele Jonathan, to accept gay homosexual practice into
Yes.
Nigeria system. Yeah. So my question now is that thank God that the then President Jonathan did not accept such offer. But
Yes.
my question now is that assuming President Jonathan accepted such kind of move, such kind of introduction, then now you as a lawyer that you are not pleased, maybe based on the contrary to our culture or whatsoever,
Yes.
how are you going to address
Okay. Now that
displeasure,
would have been
your anger? How are you going to address the issue to counter the motive?
okay. That is why they have public
I mean,
hearing before the law is made, not after the law has been made. Once the law is made, it becomes law. Now, the only thing you can do after is to call for repeal. But if the law is not repealed, it is the binding law of the land at the moment. Now, the law, that's why I shared this post, that there is public hearing. Now, what you do, even at that time, if you recall, if you followed that period, there were opposition voices, dissenting voices everywhere. There were pockets of protests to the National Assembly saying that Nigeria will not accept gay. that Nigeria is not, it is abhorrent to our culture. It is abhorrent to the different, even traditional African religion does not uphold that. Do you get it? So what you do is during the public hearing, because do not forget,
There's
the
no voice, so
national is representing you. One. Two, the president cannot sit in
Ebenezer,
his.
I can't hear you.
Oh, can you hear me now?
I'm hearing you, sir.
Hello? Can you hear me?
I'm hearing you, sir.
Okay. Mr. B, can you hear me, please? Okay, it might be an isolated case from your end, sir. Kindly check your network, Mr. B. So, I'm saying that the essence of public hearing is that this law is going to bind these people. Is it the law you want? Nigerians will come out and speak in favor or against, given reasons, overwhelming reasons why. So the fact that they suggested it to the president, even if the president himself desired it or wanted it, it is not what he can do through executive order. It has to go through a legislative process to become a law. And at the point of public hearing or one of the committees, a lot of voices will rise to say no. And once Nigerians have spoken, that becomes the position. If the National Assembly has overwhelming voices saying no, you remember when we treated the processes of lawmaking. So at the second reading, if they say those in favor of this bill say aye, and you have 3, 5, 10, 20 voices even in the House of 108, a Senate of 108, then those again say nay, and the remaining 80 or 90 voices echoes nay, that bill is negatived. It dies a natural death there, regardless of what interest any individual has. Is that okay, sir? Now, if peradventure the House is hoodwinked to pass that law, implementation becomes another thing. And that is why we have post-legislative scrutiny. That if we pass this law, after 5 years, can we look at this law again and see how is it being implemented? To what extent is it being complied? What are the factors responsible for non-compliance? One of which could be cultural, one of which could be religious, one of which could be social. A lot of factors could be responsible. Then you will now be forced to repeal that law because it is as good as non-existent, or you amend it to the way that the people will accommodate it. Does that answer your question, sir?
Yes, thank you very much, sir.
You are welcome, please. Any other question? Any other question? Any other question? Okay, I'm going to ask my own question. There are some persons I've not seen here today. Sorry, please. Ubama, is that favor? Please introduce yourself. Ubama, please introduce yourself. Hello, Ubama. Okay, not
Good
that. This is
afternoon, everybody.
good afternoon, please.
My name's Ibrahim Salisu.
Okay.
I'm a private legal practitioner. I'm
You're
joining
welcome, sir.
from Thank you. I'm joining from Nigeria, Kano, Nigeria.
Awesome.
Thank
Please,
you, sir.
sir, we have a rule here. You will kindly turn on your video and introduce yourself so that we can place a face to your name, and you tell us where in Nigeria, what city in Nigeria you are joining us from. Thank you. And how you got to hear about the training.
Yes, thank you very much. I have turned on my.
Yes, we can see you now.
You can see me now?
Yes, sir.
Very good. As I said earlier, my name is Ibrahim Salisu, a private legal practitioner. I'm based in Kano, Nigeria.
Awesome.
And I carry out my private practice from Kano. It's my base, though we go other jurisdiction also.
Yes.
Currently, I'm the Secretary General of Nigerian Law Society, Kano chapter. And
My
that is
good
where,
afternoon, sir.
Thank you, sir.
This is your boy, Ebenezer, sir.
No problem, sir.
Good afternoon, sir. We are glad to have you on the call today, sir. It's a rare privilege, sir.
No problem. Thank you, sir.
We hope to see more of your face, sir.
Okay, thank you, sir.
Thank you. Thank you.
Yeah.
You're welcome, sir.
Yeah, well, thank you.
Okay, Uboma Nwogugu, I saw you. Nwogugu Uboma, please introduce yourself. If you are joining the platform for the first time. Hello, Uboma Nwogugu. Please introduce yourself in platform. We want to know who our participants are, where they are joining us from, and why they are in the platform, on the platform, so that you are not. We will show you are in the right place, and this is where you intend to be. Not that you mistakenly found yourself here. Thank you. Okay, in the absence of any other question from your end, let me ask my own question. Can someone mention at least four components of miscellaneous provision? At least four components. Four components of miscellaneous provision. Can someone mention, okay, Madam Uju, you spoke yesterday. So today we will have Mr. Charles. Mr. Charles Tejele. Mr. Charles Jele. Mr. Charles, can you hear me? Okay, while we wait for Mr. Charles, Lekaka, can you attempt my question, please? Hello? Wait, can anybody hear me? Confirm that you can hear me first. Let me be sure I'm not talking to myself.
Can hear you.
Okay. Okay. So, Lekebo. Oh, sorry. It was Lekaka I called. I think Lekebo spoke yesterday. Lekaka. Four components of miscellaneous provision that you remember. Any four? Okay. Babatunde Adediba. No, not you, Mr. Oscar. You spoke yesterday. I want those who have not spoken before on this topic. Adediba. Hannah, I think you spoke yesterday. Mr. Babatunde, can you give us any four components of miscellaneous provision. Any 4 items, 4 clauses you think or you know should be part of miscellaneous provision. Ubama Nwogugu, I am forced to remove you from the call. We have given you enough chance to introduce yourself, enough opportunity to introduce yourself so that we'll be sure you are a part of us and one of us. Unfortunately, we are not taking that opportunity. We will be forced to remove you from the platform. Thank you.
Ebenezer, you need to
Yes,
give
Prof.
Mr. Ibrahim Salusi our link so that he will be getting the materials.
Okay, Prof. Okay, sir. I will add him on the platform.
Okay.
I will add him on the platform.
I'm most grateful to both of you, sir. Thank you, sir.
Barrister, how is Malam Sani, our VP Not?
Yes, Malan Sani is doing wonderfully well. We were together 3 days ago. I think I'll be meeting with him towards evening today in his office, God's willing.
Okay.
Yeah.
Did you remind him about this NLS pin-up? Did you get from him? And casting?
What peanuts you say?
Pin-up, NLS, Nigerian law.
Okay.
The pin-up.
Yes. Yes.
And the car sticker, did you get from him?
I have them. I have in my car for more than how many months now? I have the pin also always put on my chest.
Yes, yes.
Yes. And we have been sharing to some of our members.
Oh, that's good. That's good.
Yes.
Okay, so Mr. Obi, would you want to try? I know you are new in the class, but you were here with us yesterday and you're here today. Would you want to attempt our question on the components of at least 4 components of miscellaneous provisions? Hello, Mr. Obi, can you hear me? Okay, Oscar. The ball has finally come to your court. Okay. Okay. Thank you for that reminder. Okay. Sorry, before you fire, let Mr. Kingsley attempt first. Mr. Dediba has called you earlier. The issue is that, like I told us earlier, the more you try these things, here at this stage, we are not awarding marks. At this stage, nobody will beat you for not getting it right. Nobody will deduct from your mark. But we want you to inculcate this, to inhabit them. Let them become one with you, so that it comes as a second nature at any time. That when you are getting a brief or when you are drafting, you don't need to go and open your book to look. That does not mean you will not from time to time consult materials, no, but that a good number of these things are in your head. In fact, as you're receiving instruction, you are processing at the same time to know, okay, this can work, this cannot. You may not even tell your principal, but as you know, as the instruction is coming, you already know where to place what. So we'll have Mr. Kingsley try. We'll have Mr. Dediba try. Anyone, then before you, Mr. Oscar. So Dediba, I think you wanted to say something. You have the floor.
Apologies, sir. Apologies, sir. I was busy at the office. Apologies, sir. Okay, sir. Well, based on the simple knowledge I have, sir, one of the clauses is the one that provides for the power. Can you hear me, sir?
I can hear you.
Yes. So it provides that is possibly maybe in a statutory provision or a statutory legislation where a director general is possibly the head of the agency. So such legislation provides power. So that power clause is one of them, the clauses under miscellaneous provision.
No. When you talk power, you are talking principal provision. But if you had said power to make subordinate legislation, I would have agreed with you. But if it is authority,
Sorry, sir, that's what I meant.
Sir?
Sorry, sir, that's what I meant.
Okay,
To make
you see
subsidiary
now.
legislations. Yes,
That is it. Now you have just drafted something that is ambiguous because you did not qualify the power. You just said
right,
power. So that's what we are talking about. As you just said power, I have gone to the Establishment Act. I said that, yeah, the Establishment Clause, which is under principal provision. But if you are saying power to make subordinate legislation, we will agree with you. Okay, so power to make subordinate legislation, agreed. Which other clause can we find there?
Okay. The one that provides possibly registration. Can you hear me, sir?
Licenses and
Yes,
registration.
registration.
Thank you.
Yes.
Which other one can
Yes,
we find there?
Okay, the clause that provides the processes, or maybe you can call it, yes, processes or procedure of
For doing what?
seeking, maybe appealing a
Beautiful.
punishment.
Beautiful.
Exactly.
You have given us 3. It's remaining 1, and you are doing very well. So can you give us 1 more? Then we leave you alone. Just try.
Okay, sir. Okay. Uh, I can't. Sorry, I can't think of anyone now, sir.
Yeah, you have done well. So we talked about notices, pre-action notices, for example. Do you get it? Then if it is for corporate body, maybe notices for
Yes,
meetings. Do you get it?
I do, sir.
So good. So can we have Mr. Kingsley now? Mr. Kingsley, are you ready for us? Hello, Mr. Kingsley. Okay, Mr. Oscar, today is your turn. Oh. Yeah, yes, yes. Jurisdiction is there. Yes. Okay, but there are more of them. Enforcement procedure. Beautiful. Beautiful. Do you get? So there are lots, not just this, there are a lot more within the purview of miscellaneous provision. anything you can think of that the defense lawyer can use as a club to protect the defendant or suspect and make the law ineffective against that particular suspect based on the content of the law, you put it under miscellaneous provision. So, gentlemen, we have overshot our time for lecture today. I'll be drawing the curtains here. However, the assignment for week 6, not too many people have submitted their assignments. Please endeavor to do the assignments, and by Friday this week, Saturday, you'll be getting the assignments for week 7. So it's at this juncture that I'll be drawing today's class to a close. Tomorrow, I will post the link earlier than the time it was posted pretty late today. I apologize for that. Tomorrow, we'll meet again and continue from where we stopped today. Thank you very much and have a blessed day.
We are very much obliged. Thank you, sirs.
Thank you.
Thank you very much, sir. God bless you, sir.
Thanks, sir.